Greetings everyone. This is Ayushi Singh, Executive Member of Legal Vidya. I welcome you all in the 7th class of AIBE crash course organized by Legal Vidya. So without further ado, let's warmly welcome our esteemed speaker, Advocate Nivedita Kondinia ma'am, to the virtual stage. Over to you ma'am.
Thank you, Ayushi. Good evening, everyone. So let us begin our session. And in today's class, we will be dealing with the Code of Civil Procedure and the public interest litigation. So let me share my screen and we will just go with it. Are you able to see the notes or anything on my screen? Okay, fine. So we will start with PIL and then we will go to the CPC portion. So for public interest litigation, there is no bare act, and you have to remember all the things. That is why I have prepared this document, and I have mentioned all the important points. So you will not get questions apart from whatever has been mentioned here, but just read it carefully and learn all the important points. Okay, so that you will be able to attempt the questions. So public interest litigation is a legal mechanism wherein any public spirited citizen or a social organization, they can move to the court for the enforcement of a right of society or public at large. Okay, so there may be an interest of community or a number of communities or a particular state, or maybe a number of a state, or some general problem like the issue of pollution or the issue of fresh air. So if there is some public related issues, and when any person moves to the court, sorry for the disturbance. So a public anyone who is having who is a legally aware person, or who thinks that whatever issue he is suffering or she is suffering is something which is suffered by a whole community itself, or maybe he may be someone who is not suffering the issue, but he understands that this issue is of public importance. This issue holds a very important position, and therefore it has to be dealt. So that person moves to the court, or that organization moves to the court, so that the enforcement of that particular right could be done by the court. Now, for example, we in the recent times, in the recent past, around 5 to 6 years, we have seen a number of public interest litigations which have somehow led into very landmark judgments, right? For example, the case of triple talaq, it was also through way of public interest litigation. The case of adultery, the decriminalization of adultery, it was also a public interest litigation. The case of Ayodhya, it was also public interest litigation. Although it was a private transfer, private property issue, but later on it also got attached with a public interest litigation. So there are number of cases in the recent years where you will find that there, due to some spirited person, or due to legal awareness of some person, or due to activism of some person, we have seen a number of landmark judgments. We have a number of decisions which have transformed our lives, right? So, a public in a PIL, any member of the public who is having sufficient interest. Okay, so there has to be some sufficient interest in the suit to call for it to be called as public interest litigation. So any person who is having a sufficient interest in the issue, then he can approach the court to enforce the rights of other persons and redress a common grievance. Okay. The Supreme Court has defined public interest litigation as a legal action initiated in a court of law for the enforcement of public interest or general interest, in which the public or a class of a community have pecuniary interest or some interest by which their legal rights or liabilities are affected. Okay. So, as per this definition, PIL is a legal action which is initiated in the court of law, but it is initiated for the purpose of enforcement of a public interest, or for enforcement of a general public interest, where some person has initiated this, or some organization has initiated this legal action. Also, in this legal suit, there has to be some interest of the community. So that interest may be a pecuniary interest related to finance or money, or it should be also some other interest. For example, the interest of health of the general public. So there are number of MC Mehta versus Union of India cases where there is issue of pollution, pollution of Ganga River, whatever. So, or the oleum gas leak, and whatever hazards has been suffered by some companies, or how absolute liability of a state could be fixed. So all these things have been done in India through by the way of public interest litigation. Okay, therefore this is a very important topic. And for us advocates who are you all are future advocates, you may be joining some other professions also, but since you all are preparing for AIB, so I would suppose that you all are future advocates. So for all the future advocates, public interest litigation is a tool to transform the society. Okay, now let's move forward to there are some other names of public interest litigation also. So it is also called as social action litigation, or social interest litigation, or also class action litigation. So if you find any of these names instead of public interest litigation, then don't get confused. Okay, these all are same. Now moving to the objectives of the public interest litigation. Why public interest litigation is being promoted, why it has been in so much boom since the last 20-30 years, because it is a vindication of the rule of law. It establishes the rule of law. It promotes, or it showcases that rule of law is not only limited to someone who is actually facing some issue. There can other person can also raise some issue which is faced by community at large, and that issue will be entertained by the court of a state which is a welfare state where rule of law is there. Okay, it is also felicitating the effective access to justice for the socially and economically weaker sections of the society. And it also objects for meaningful realization of the fundamental rights. So these are the objects of the public interest litigation. Now, how the PIL originated? So we can historians or the legal experts traces the concept of public interest litigation to USA back in 1960s, and it was in USA it was realized that the ordinary marketplace for legal services was not able to provide for the legal representation to a significant segment of the population back then, and their interests were not being represented in the courts. Therefore, PILs were introduced, and it was designed so that legal representation could be provided to such unrepresented groups and interests. Okay, how PIL got introduced in India and how it evolved. So PIL was introduced in India in early 1980s, and emergence of PIL is mainly attributed to judicial activism of the Supreme Court, wherein Justice V.R. Krishna Iyer and Justice P.N. Bhagwati was the pioneers of this concept. They have allowed a number of PILs which have resulted into landmark judgments, right? So they are also called as the pioneers of the concept of PIL in India, Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. The introduction of PIL in India was felicitated by relaxation of the traditional rule of locus standi. So, locus standi is the rule of the court wherein it is said that only that person whose rights are infringed alone can move to the court for remedies. So, if you are an aggrieved person, then only you can approach the court so that your right could be enforced. So, this was the principle of locus standi. There has to be some reasoning behind your standing in the court of law. Why you are coming to the court, why are you approaching to the court. So there has to be some relation, direct relation between that, but PIL is an exception to this rule. So it is evolution from the traditional rule of locus standi to something else, where a person who is not directly affected by the issue, who is not involved in the issue, he or she can also approach the court so that community at large could get the benefit of it. Okay. So we have this case of MC Mehta versus Union of India, where Ganga River pollution was discussed. Okay, so MC Mehta as a person was not directly involved in the issue. He was not the one who was suffering from it. But if we broaden our perspective, MC Mehta as a citizen of India is the person who thought about all the lakhs of people or crores of people who are living and who are earning, or and whose whole life is situated and is revolving around the banks of the river Ganga, and all of them, and Ganga being the largest river of India, is also source of income and source of economy for the nation as well. So if it Ganga is polluted, and if it is not in the good state, it will affect the health of the public at large, it will affect the economy of the country, and it will also affect the natural and scenic beauty of our country also, and also it will also affect the life which is living in the river. So considering all these factors, MC Mehta is the person who is getting affected by it, because whatever uh, thing is happening in the nation at such a large and it is having such a large impact, then it will also affect the citizen of the country also, right? So that this is how the PIL is the principle of PIL evolved in India, and this is how locus standi principle was sidelined so that PIL could bloom, right? Now I have also listed some famous judgments which is related to PIL in India, and they are Mumbai Kamgar Sabha versus Abdul Thai. It was a 1976 judgment. In this case, Justice Krishna Iyer laid that the foundational concept of PIL in India, promoting the idea that collective societal issues could be addressed through legal channels. Okay. Then we have SP Gupta versus Union of India case. In this case, Justice P.N. Bhagwati expanded the scope of PIL, and he stated that any member of the public or social action group acting bona fide could invoke the jurisdiction of high courts or the Supreme Court to seek redressal for the right of those unable to approach the court due to disabilities. So this judgment was a very important judgment to establish PIL as a tool for enforcing public duties and to address executive misdeeds. Then we have case of Indian Banks Association, Bombay and others versus Miss Devkalla Consultancy Services and others. In this case, the court declared that even a case filed for personal grievance could be considered under PIL if it serves the public interest, enhancing judicial oversight in matters affecting societal welfare. So sometimes court, through judicial activism, it also looks upon the matter which is which is in its hand. So if it sees that any matter has been brought by some personal interest from a person who is having a personal interest in it, but at the same time that matter is affecting a large community of the people, it is affecting general the public at large. So in this moment, the court will treat it as a public interest litigation. Okay, and then it will deal it as a public interest litigation, and whatever guidelines it will give or whatever remedies it will pronounce in its judgment, that will be applicable to all those who are being affected. Okay, then we have case of MC Mehta versus Union of India 1998, which is the Ganga River pollution case. In this environmental PIL, the Supreme Court ruled that the petitioner did not need to be a riparian owner to challenge pollution in the Ganga River. Okay, the case emphasized the right of any concerned citizen to seek enforcement of the environmental laws for the public good. Now let's move to some important features of public interest litigation. It provides strategic arm of the legal aid movement. It it promotes cooperative efforts. It is distinct from the traditional litigation because PIS does not involve dispute between two opposing parties who are seeking relief. Instead, it focuses on promoting and vindicating public justice. It promotes public interest. It addresses violation of the rights. It redresses public injury. It asserts the role of the court, where the courts play a more assertive and proactive role compared to the traditional courts back then, and it creates a creative approach to determine actions and outcomes towards helping the disadvantaged persons or sections in the society by the courts. Also, it is a flexibility within judicial tenets. Okay, as compared to the traditional cases, PIA proceedings adopt a flexible approach. Also, they are more into considering the principles of natural justice, good conscience, and public good, and uh, and they are very flexible in nature. Now, why public interest litigations are important? Because it aids the implementation of DPSPs. Okay, so Article 39A under DPSP provides that what it provides, it wants to provide, it directs the state to secure equal justice and free legal aid to all the persons and to poor especially. So through PIL, this purpose, which is directed by the DPSP itself for to the government, it is also getting secured, or it is getting aid by PILs. It allows public spirited individuals to fetch rights, and it allows them to access justice for the rights of the marginalized and disadvantaged sections. It enforces the rights of authorities, and it holds the authorities accountable for their actions or inactions. It promotes public interest, and it promotes judicial activism. It promotes social reforms, and it promotes accountability. Okay. Now, there are certain concerns also which are related to public interest litigation. This is not important for examination purpose, but just give it a read. Now, there is this very important guideline which was issued by Supreme Court, okay, and it is based on the full court decision dated 1988, but it was also amended in 2003 also, okay, and this guideline was issued based on the decision of 1988, but it was issued by the Supreme Court later on, and then in 2003 also there were certain improvements which were made into it. So these are the guidelines. The court very clearly said that no petition involving individual or personal matter shall be entertained as PIL matter except as indicated hereinafter. Okay, so basically any petition as we discussed, if it is having any individual interest or a personal matter, cannot be entertained by the courts as PIL matter, except whatever has been mentioned here. Okay. Also, letter petitions falling under the following categories alone will ordinarily be entertained as public interest litigation. So, in case of PIL, even a single letter which is written without any format is also considered as a PIL by the Supreme Court. Okay, it has been allowed by them. But Supreme Court in this guideline has laid down that no, not all letter petitions will be allowed. Only that will be allowed where these issues have been dealt in. And what are the issues involved? What issues should be there so that letter petitions or public sorry individual matters could be considered as PIL? Here are they. Number one is if it involves the issue of bonded labor matters, if it involves neglected children, if it involves non-payment of minimum wages to workers and exploitation of casual workers and complaint of violation of labor laws, petitions from jail complaining of harassment, of premature release, etc., or maybe death in jail, transfer, etc. So you may find a number of guidelines. There are 11. So these 11 situations have to be complied with so that only those matters, in these matters only letter petitions will be treated as PILs. Okay. Also, all letter petitions received in PIL cell will first be screened in the cell, and only such petitions as are covered by those above mentioned categories will be placed before a judge to be nominated by Honorable Chief Justice of India for directions. Okay. So basically, why these guidelines were necessary is since the court allowed the letter petitions, there were multiple letter petitions. Okay. So you cannot stop the public from sending the letter petitions. And therefore, but again, you cannot present all the letter petitions for review, and after that, after review, it will be presented to the judge, and judge will be dealing with it, and then he will be disposing it. So, to save the time of the court, the Supreme Court laid down these guidelines. So, if there are issues involved, the issues which have been listed here, only then that later petitions will be treated as PIL, and that will also be placed before the judge, and afterwards will be listed in the court. So, this was all from this topic, and just go through the points. Remember all the important points. Just mug up all the important case laws, and that will be sufficient for public interest litigation for this examination. Okay. Is there any confusion or any question from this portion? And if not, we will move to CPC. Okay, so I suppose there are no such questions. I have shared the document, go through it. And if you have questions, you are always welcome to post it in your WhatsApp group, and I will be addressing that. So let's come to the topic of CPC. Now, CPC is a very big legislation. It is having a lot of sections, a lot of orders, and it is very lengthy document, right? So, for AIBE purpose, all you have to do. Okay, so for CPC, what you are required to do is you are not required to go through the whole Bare Act or to mug up all the sections or to read all the Bare Act. Okay, so you have to focus on some basic definitions. You have to be aware of what order contains what provision. Okay, in what part you will find what provisions, and just remember the headlines of all the orders, and you will be able to do all the questions from CPC, right? I have mentioned here what sections should not be focused upon, because these are some sections which have never been asked in the examination, which are not at all important because there are no important provisions in these sections. Okay. So uh, just go through open your content of your Bear Act, go through all the parts, whatever headlines are provided there. Just remember the part and the headline it contains, right? So what part contains which provision, you will be able to recall. And after that, remember some important orders. For example, order 1, order 2, order 5, order 6. Then we have order 7, order 10, order 16, order 20. Okay. So and also this order 20. No, not this one. Yeah, order 27. So with just by remembering these some basic orders and what they contains, you will be able to navigate through CPC. Also from CPC portion, you will only find direct questions from the act itself. So you are not required to mug up anything for the purpose of this examination. Apart from that, you have to remember everything because no other examination will allow any bare act there. Okay. But for the sake of this examination, just uh, just go through your content properly. Just be aware of where what provisions you will find in which section or in which page, and it will be enough for CPC. So let me discuss some basic definitions. After that, we will go through some important points, and then we will discuss some questions. Okay. So CPC, you will find the object in the preamble itself of the act. You will find the enforcement date and the enactment date of CPC. Then we have three very important amendments to CPC. You are not required to go through the amendment, but just remember that these three amendments were very important. And I have also listed them in the document. They are the amendments of 1976, 1999, and 2002. They are as important to the CPC as amendment 42nd amendment to the Constitution. So just remember that these three amendments were there, and in among these three, 1999 and 2002 amendment was challenged also. And then we have this landmark case of Salem Advocates case. Okay, and where you will find the judgment. So we will go back to the judgment. Just first of all, let us discuss the object, the enactment clause. Okay, so it was enacted on 31st December 2015. It provides for, the preamble says that it is an act to provide for the constitution of the commercial courts. Also, commercial appellate courts was also added by 2018 amendment. Commercial division and commercial appellate division in the high courts for adjudicating commercial disputes of specific value and matters connected therewith or incidental thereto. So basically, CPC deals with the constitution of commercial courts. Sorry. I am reading the wrong one. Okay. So the preamble of CPC, I was reading the preamble of one amendment and I was thinking that how this it got changed. Okay, so the preamble says that this is an act to consolidate and amend the laws relating to the procedure of the court of civil judicature. So CPC is a procedural law which deals with the procedures of the courts, and of which court? Of civil judicature, right? And CRPC or BNSS deals with the criminal judicature. And it was enacted on 21st March 1908. Then we have certain definitions, but we are not going to discuss the definitions because usually definitions are not asked in the examination. You will get questions from the orders and rules and to some sections, and that you will be able to do it from the Bare Act itself. But Now let us discuss some important topics or some important definitions. So you will find mesne profits, right? It is a term which has been mentioned under section 2 clause 12. Mesne profits means mesne profits of a property means those profits which the person in wrongful possession of such property has actually received. Okay, so a profit which has been received by a person from a property which was not his own and it was in his wrongful possession, right? Or he might with ordinary diligence have received therefrom, together with the interest on such profit, but shall not include profits due to improvement made by the person in wrongful possession. So say suppose A is the person who has been into wrongful possession of the plot of C, okay? And what he has done is he has somehow managed to get some crops planted over it, and he was getting profits from it. So that will be called as mesne profits. Okay. Then we have definitions of relating to the provisions of facts. We have the terminology of facta probanda. Where is it? Yeah, facta probanda and facta probantia. So what are these terms? Facta probanda means the facts which is required to be proved, that is the material facts. And facta probantia is the fact by means of which they are to be proved. So basically, facta probandas are the material facts which are the important facts in the question or in the issue, and those particulars and those evidences which are required to prove those material facts will be called as facta probantia. Okay. Now, why is it important? Because the CPC says that under the topic of fundamental rules of pleadings, it says that you have to plead facts, and you are not required to plead law while you are making a pleading. Okay, in the civil code, it is the duty of the parties to state the facts only and not the law. It is for the court to apply the law to the facts pleaded, right? So, as a person who is approaching a civil court for enforcement of any right relating to his property or any of civil nature, then in such a situation he is only required to state the facts which is relating to his issue. Okay, he is not required to mention all the laws which will be attracted by his issue, or he has nothing to do with the laws. He is only required to state the facts. And who will apply the laws? It is the duty of court, because court knows that which law will be required where. So parties should not be wasting their time also, and they should not be wasting the time of civil courts also by mentioning the laws. So the courts will then be required to find the correctness, if the law which has been mentioned is actually correct or not. So all you have to do in a plaint is to just write the plain facts. Rule 4 provides that cases in which particulars are to be given. Okay. And it provides that in all the cases in which pleadings relies on misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other necessary cases, the particulars shall be stated in the pleading. Basically, in the pleading, all the particulars regarding that what happened and how misrepresentation was caused, how fraud was caused, how the party suffered, everything, every particular shall be stated in the pleading. Okay. Also, the second rule is that you have to plead facts and not evidence. So basically, you have to only present the facta probanda and not facta probentia in your plaint while you are pleading, right? So facta probantia will be used at the time when trial will begin. The civil court proceeding will begin. So when civil court will institute your suit and it will call for hearing, then only at the time of hearing, your facta probanda, that is your material facts which has been mentioned in the plaint, will be proved by the required evidences, and other particulars. You are not required to mention those evidences and particulars in your pleading itself. Okay. Then let us discuss the definition, not definition, but difference between a preliminary decree and the final decree. And before that, let us discuss what is a decree. So, section 2, clause 2 of the code defines decree, and decree means a formal expression of adjudication, which, so far as regard the court expressing it, is conclusively determining the rights of the parties. Okay, so decree determines the rights of the parties conclusively with regards to all or any of the matters in controversy in the suit, and it may either be preliminary or it may be final. Now, what essentials are required in a decree? That there must be an adjudication. If there is an adjudication, only then a decree will be passed. And such adjudication must be done in a suit. The rights of parties should be there in controversy. It should be the conclusive determination of the rights involved, and it is a formal expression of the court. Okay. Then we have two very important terms, res sub judice and res judicata. I have not mentioned this in this document, but just note it down. Just these two are there, which I have not mentioned. So, res sub judice and res judicata. Section 10 lays down the rule of res sub judice, which prevents the court of concurrent jurisdiction from simultaneously adjudicating upon two parallel litigations in respect of same matter between the same parties. Again, it lays down it lays down that a civil court of a concurrent jurisdiction is not allowed from simultaneously adjudicating upon two parallel litigations. Okay, and parallel litigations relating to same matters between the same parties. Okay, so if there is a litigation going on between two parties, no courts are allowed to carry on the parallel litigation in some other court between the same parties relating to the same issues. Okay, this is the rule of res sub judice, where res means a thing or a matter, and sub judice means under consideration. So, if a matter is under consideration, then no court shall proceed with the trial of any other suit relating to that matter which is an issue. Okay. Then we have principle of res judicata, and it is dealt under section 11 of the code, and it is also called as rule of conclusiveness, where res means dispute and judicata means decided. So if res judicata means a matter which has been adjudicated, so res sub judice means a matter which has not been decided yet, it is a pending adjudication, and res judicata means a matter which has been adjudicated. So this principle is based on the need of giving finality to judicial decisions. Okay, and it applies between past litigation and future litigation. And what does section 11 or this rule provide? That no court shall try any suit or issue in which the matters which are directly or substantially in issue has already been decided. Okay, so if a matter which is abroad in the court, and it is a matter on which decision has already been given by some other court or the same court, then then the court will not again hear that case. Okay, so if we differentiate between both the rules, res judicata and res sub judice, res judicata applies to the matter which has already been adjudicated, and res sub judice applies to the matters which are in pending trial. Res judicata bars the trial of the suit or an issue which has been decided in the former suit, and res sub judice stays the trial of the suit which is pending decision in previously instituted suit. Okay. And thirdly, interim orders cannot be passed in the cases where res judicata is applied. However, an order of stay of suit does not take away the power of court from passing interim orders, right? So this is the difference. Also, since I have not mentioned this topic in this document, I will be sharing it after the class. I forgot to mention it in there. So with this, we are done with some important key points or keywords in from CPC, from which questions may come. Other than that, we are done with everything, and I have told you the trick as to how to navigate through CPC. And then let us move forward to discussing questions. Oh, I have not discussed this case law. So, as I told you before, the major amendment of 1999 and 2002 was challenged in a case. It was a case uh, called as Salim Advocates case, and in this case, both the amendments were challenged, and it was it in this case, constitutional validity of these amendments have been in question. So the Supreme Court formed a committee which was headed by former judge of the court and the chairman of the Law Commission of India, and the name of judge was Justice M. Jagannatha Rao. Okay, and under the headship of Justice M. Jagannatha Rao, this committee was set up by the court to suggest modalities for operation of amendment. The honorable judges who presided over this case were Y.K. Sabharwal, D.M. Dharmathikari, and Tarun Chatterjee. Now, what happened in the case was that the petitioners challenged the constitutional validity of the amendment which was made in CPC, and this which was rejected by the court. But it was noticed in the judgment that modalities have to be formulated so that in which section 89 of the code, for that matter, and other provisions which have been introduced by amendments can be operated. Okay. And the committee submitted a report in three parts, where in report one, it's talked about the consideration of various grievances. In report two, it drafted rules for ADR and mediation. And in report three, case management conference was provided. Now, section 89 is very important. Why? Because through this amendment, section 89 provided ADR. ADR is alternative dispute resolution. We will be doing this topic in the next class also, because it is a separate topic itself. Okay, but it is the section 89 which actually provided for ADR, right? And ADR includes four types of dispute resolution mechanism, where out of the court settlement can be achieved, and in the compoundable matters. So we will be dealing with that in later on. So let us discuss sample questions right now, and this will be all for today's class. Are you able to see my screen? Okay, let me show you. Wait. Is it visible now? What is the Okay, let me share it with my phone itself. Just give me a moment. Okay. So now let us discuss some questions relating to CPC. And you will see that these are very direct questions and you will be able to directly access these questions. Okay. So the first question is, under Civil Procedure Code 1908, every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. This is provided under. Okay. So you will go through this statement. You will see the statement. You will go to the order. Now, if you will follow the, you will be able to follow my advice. If you are remembering the orders, right? If you are remembering in which order what provision has been mentioned, so you will be able to do it. Otherwise, if you are not even remembering anything, okay, whatever has been asked, so you have four options. You will go directly to section 26. You will see, okay, it is not provided there, and then you will see section 20, it is not even provided there. Then you will have order 3 and order 4, right? So in the same manner, you will see order 3 and order 4, and you will see that it is not provided there. But then you will be seeing order 4, which talks about institution of suits, right? And here the question is relating to institution of suit itself. So you will get this idea that this may be found in order 2, sorry, order 4. Then you will go to order 4, order 4 rule 1, and you will find that this provision has been provided there. So the right answer will be order 4 rule 1. Okay. So which provides that rule suits to be commenced by the plain. And here what is being asked, every suit shall be instituted by presenting complaint in the duplicate to the court or such officer as it appoints in this behalf. And this is provided under where? So you will see that there itself. Coming on to the next question. A defendant under order 5, rule 1, clause 1 of CPC 1908 is required to appear and answer the claim and to file the written statement. Now here in options, timeline is provided, right? But this is a very direct question. Order 5, rule 1 has already been mentioned. So just go to the order 5 and rule 1 and you will find the answer, okay? And the answer will be within 30 days. Let me show you at least. Yeah, so just a second. You will see in order 5 rule 1, you will see that it is provided. It is talking about issue and service of summons. And when a suit has been duly instituted, a summon may be issued to the defendant to appear and answer the claim and to file the written statement in his defense, if any, within 30 days from the date of service of the summons to the on the defendant. So the right answer will be within 30 days from the date of service of summons. Then under which of the following sections of CPC inherent power has been provided to the courts? Okay. So for this, you have to go to the content clause and you will see in the contents where inherent powers could be found. So and also you are seeing the sections. These are very sections which are very close. So just go to section 148 and afterwards see in which heading you will find the thing which has been already which has been asked. Okay. So you will see that it is section 151, which provides about the inherent powers of the code. Okay. Then which one of the following sections of the code of CPC provides for the trial in open court where the public may have access? And the answer is 153B. You will see in section 153B where it has already been provided that about the inherent powers of the code. So you will just see the heading, okay, where it says that uh, savings of inherent powers of the code. So you will see that inherent powers of the code has been mentioned in the section 151, and that will be the right answer. Then which one of the following section of the civil CPC provides for the trial in open courts where the public may have access? And again, you have to do the same thing. Just go through that, and then you will find that it is section 153B, where it is talking about places of trial to be deemed to be open court. Now, open court is something where public may have access. So, your answer will be section 153B. Then, a suit under Civil Procedure Code can be filed in a representative capacity. Now, representative capacity is the keyword which you have to search, and you have to search only between these. So order 1 has already been mentioned, and you will see that all the options are from order 1. So you will just go to the order 1. In the content itself, just go to the order 1, and you will see from order 8 to order 10 that it is rule 10 where, sorry, not rule 10. I think I have mentioned the wrong answer. Okay. So it is A, with where the it is order 1 rule 8, where it is provided that any person could file in the representative capacity, because the heading is one person may sue or defend on behalf of all of the same interest. Okay. Now coming on to the next question. So if this document has been shared to you, then just correct this answer. It was it was option A, and I mentioned D. Next is, an executing court can modify the terms of a decree, or it can vary the terms of the decree. It can modify and vary the terms of the decree, and it can neither modify nor vary the terms of the decree. So you will see where the executive court has been provided, the provision of regarding executive court has provided, and it is provided under part 2 of the act itself. And you will see that the answer is that an executing court can neither modify nor vary the terms of the decree. Okay. Then in the next question, the general power to transfer suits under section 24 of Civil Procedure Code has been granted to. So since section 24 has already been mentioned, go to section 24 and you will find the answer that it is both High Court and District Court. Okay. So in this way, you will be able to find your answer. Okay, let me read this provision so that it is clear to you. So section 24 talks about general power of transfer and withdrawal, right? And it says that on application of any of the parties and after notice to the parties and after hearing such of them as desire to be heard, or of its own motion without such notice, the High Court or the District Court may at any stage. So you get your answer that it is both High Court and District Court. The next question is, set off can be. Now you have to find the you have to search this keyword set off. Okay. So where you will find the set off, you will search in the you will search it in the content, and then you will find that it can be both legal set off also, and it can be also equitable set off. Okay. So the right answer will be both A and B. Then similarly, there is this question, place of institution of suit in respect of immovable property situated within the jurisdiction of different court has been provided. So you will go through these sections and you will find the heading. So if the heading matches with this, you will be able to find your answer, which is section 17. Now, if it is not clear from the heading, I would suggest just go to the provision itself and read the provision once. Very quickly read the provision. It is 3 hours and it is very sufficient time to do so. So just read the provisions. Don't make wrong choice in haste. Okay. Then the next question is issues must be confined to facta probanda, facta probantia. Now here you will not be required to even go to the bare act, because now you know what is facta probanda and you know what is facta probantia. So issues in a plaint has to be related only to facta probanda, because facta probantia will be required only during the proceedings of the suit. Okay. In a suit of maintenance, arrears can be claimed for the last. So similarly, you have to see where suit of maintenance has been provided, and then you will find the provision. So it is provided that in 3 years arrears can be claimed. Then again, by which judgment the Honorable Apex Court upheld the constitutional validity of the amendments made in the CPC by the Act of 1999 and 2002? And the right answer will be Salem Advocates Bar Association, Tamil Nadu versus Union of India, which was decided in year 2005. Okay, so this is how you will be doing the portions relating to CPC. And for the PIL, you have to just read the material which I have provided, and that will be sufficient for the purpose of this examination. Okay. Now, in tomorrow's class, I will be discussing ADR, ADR and the Arbitration Act, including the Arbitration Act, then the environmental laws, and we will be doing Limitation Act and Negotiable Instrument Act, which are very short acts, so we will be able to cover all the things. Regarding environmental law, it is having a large number of acts, but we will be only dealing with what is important. So Limitation Act, Negotiable Instrument Act, Environmental Act, ADR, and arbitration. Okay. I think this is all from my side today. If you are having any questions, you may ask. Yes, Pradeep. Do you have any questions, Pradeep? Is it by mistake that you have raised your hand? Okay, okay, fine. So, Ayushi, you may end the session now.
Thank you so much, ma'am, for such a wonderful session. And thank you, everyone, for joining.
Thank you. Just read whatever I have